Good morning, everyone. Thank you so much for joining us for this exciting event today, and welcome to our webinar on Caribbean Data Protection Acts, expectation versus reality. You know, those two things can be very, very different, right? Expectation and reality. My name is Kalilah Reynolds, and I will be your host for this morning's events. I'm a business and finance journalist. I'm an author. I'm a host, among many other things. And like you, I have a keen interest in data protection and the new changes that are coming into effect across the Caribbean surrounding data protection. I know that it's going to be a lively and informative conversation. I see some of you already engaging via the chat, and we love to see it. Today, we'll be taking a closer look at the laws that regulate how data is processed and protected across the region, how those laws can impact your business, what it takes to be compliant with those laws, and we'll dive into the actionable steps that your organization can take to ensure that your critical data and that of your clients, very important, is fully protected in this ever-evolving landscape. So joining me to answer your questions will be Cloud Carib's Director of Public Sector, Eamonn Sheehy. Eamonn has served in that role since 2018 and has been responsible for promoting national digitization strategies to governments around the region. He brings with him over 30 years of experience in public sector information technology matters, having worked with organizations like the Irish Revenue Commissioners, the European Commission, and the World Customs Organization, that's the WCO. Also joining our panel this morning is Rishi Maharaj. Rishi is a data protection advisor and managing director of Privacy Advisory Services, helping Caribbean businesses navigate the complexity of data protection laws. In 2009, Rishi served as the team lead in drafting data protection legislation in Trinidad and Tobago. He also developed data protection compliance programs for several regional companies. Rishi is a member of the International Association of Privacy Professionals and is also a certified information privacy manager. Now, as we wait for any latecomers to join, we do have a few housekeeping notices. This webinar is meant to be interactive. We want you to participate. It's interactive and informative. If you have questions, feel free to drop them in the Q&A section at any time by clicking the three dots. So if you're not familiar with WebEx, there are, three dots at the bottom right of your computer screen. And we'll attempt to answer as many of those questions as we can as time allows. You may also join our chat and participate in the various polls, which will pop up on the right side panel, also called Slido. All right, so just a quick note as well. So you're going to use the Q&A section to ask your questions, and we ask that you distinguish that from the chat because, you know, many running comments tend to go in the chat. But if you have something specific that you want the panelists to answer, it's easier for us to find those questions if you use the Q&A tab on the right side of your screen. Those three dots right there, click it, and you will see the Q&A section come up. We will be taking your questions towards the end of the program, but do not wait until the end of the program to hurry up and type in your question. It's best if you type it as we go along. Like as you think of the question, just write it in there immediately. And perhaps if it's something that the panelist is addressing in the moment, he may be able to incorporate that as well. So just type your questions as we go along, and that way you have a better chance of your question being answered. So welcome again to those of you just joining us. My name is Kalilah Reynolds, and today's webinar is brought to you by Cloud Carib. And for those of you who may not know, Cloud Carib is a managed services provider based in Nassau, Bahamas, that caters to Caribbean public and private organizations interested in moving to the cloud by helping with cloud migration, data backup and replication, disaster recovery, and cybersecurity, among other services, with a network of data centers spread across the region. They are an SOC2 compliant managed services firm, which is ranked number 28 of 501 by the prestigious MSP 501 list, making them number one in the Caribbean. If you're interested in a custom solution that fits your company, contact information will be shared with you in today's session, or you can just email contact@cloudcarib.com. So we're just about ready to begin. So let's actually kick things off with a quick poll to see where everyone is on their cyber hygiene journey. You'll see a poll show up at the bottom of your window that will be live for a few minutes. So please participate, and let's take a look at the first poll. The first poll is actually, how familiar are you with the data protection laws in your country? So let us know. Take the poll. How familiar are you with the data protection laws in your country? I see it popping up here because I want to take the poll too. So how familiar are you with data protection laws in your country? Very familiar, somewhat familiar, very little, or none at all. So I just took it too, put in my answer, and I'm curious to see what the majority of you are saying. How familiar are you with the data protection laws in your country? All right, so now that we have started taking the poll, we're going to see how everyone answers shortly. And if you change your mind at the end, will you feel differently about this question if you've learned something from the presentation? So in today's webinar, we're going to look at both the expectations and the realities of the Data Protection Acts in the Caribbean, and hopefully provide some key insights which your organization can use to ensure that your data is in fact being protected. Now, compared to the rest of the world, we're only now seeing Caribbean countries pick up the mantle in terms of data protection regulations, or GDPR. So let's start this panel. Let me bring Rishi in to start. First of all, hi, Rishi.
Hi, Kalilah. Thanks for welcoming you, and thanks to all the participants who are here today.
May I ask where you are in the world this morning?
Sunny Trinidad and Tobago. It's nice and
Lovely.
sunny and hot today.
I like that we can do this, like virtual interviews and virtual forums have just opened up the entire world. I can be in Jamaica, you're in Trinidad and Tobago, Cloud Carib is in the Bahamas, and we're all connected here, and our participants are all over the Caribbean and all over the world as well. So let's start with you. Compared to the rest of the world, we're only now seeing Caribbean countries pick up the mantle in terms of general data protection regulations, or GDPR. And we've seen legislation passed in the Bahamas and Trinidad, two countries which led the way in terms of being first out the gate to pass those laws. But we've also recently seen countries like Barbados and Jamaica enact their own data protection acts. So as someone who has had direct involvement in the creation of regional data protection legislation, here's my first question for you, Rishi. Why should organizations care about data protection? Can you provide an overview of GDPR type legislation currently being enacted in the Caribbean?
Thanks very much for that question. Why should organizations care? I think we now live in a post-pandemic world. And of course, during the pandemic, we know a lot of companies took that opportunity to enhance their digital presence in the world. I mean, a lot of companies, particularly in the Caribbean, began to offer e-services and began to use technology in a different way than it did before. We've also seen where citizens have now become more aware of the types of personal data that they put online, but also the types of personal data that is collected on them through different companies and through different ways that they engage with companies out there. So companies need to care, because I like to come at it from the avenue of trust. In that if I have to do business with you, or if you want me to do business with you, engage in services with you, obviously that will involve me giving you certain types of personal data. And I have to trust that you will utilize my data in a transparent, accountable way, that you will put the proper security things in place to protect that data, and that you would not use it for any other way than we initially agreed how the data should be used. So that level of trust is something that I think citizens and people throughout the region are now becoming aware of and are now beginning to ask questions of companies as to why do you want so much data? How are you going to use it? And what we've seen is, especially again, as Caribbean governments are now embracing this whole e-movement and are moving towards e-government services and other things besides private sector. And again, also because of trade agreements with international countries such as the EU and Canada, for example, countries are now being, I wouldn't say forced, but realize that they have to put proper frameworks in place to protect the data of their citizens in the world we live in. And many countries have begun to use the General Data Protection Regulation, or GDPR, as the benchmark for developing their laws. So, for example, recently you cited Barbados and Jamaica, two countries which recently implemented their laws and have appointed commissioners, have used the GDPR as their base foundation for developing their own particular acts. We have the Cayman Islands, Bahamas, Bermuda, British Virgin Island, Belize have also passed similar types of legislation. So there's a growing movement in the Caribbean with countries to begin to pass laws, not only to enforce the way companies deal with data, but also to protect the data of their citizens.
Thank you so much, Rishi. So that's really great information, and it's a good point for us now to take a look at the answers to our poll. And I see the vast majority of you said you're somewhat familiar with data protection laws in your country. So 47% saying somewhat, 31% saying very little, 14% saying very familiar, and 8% saying not at all. So most of you have at least some knowledge of this topic, and of course you are here today to learn more. Now let's welcome Eamonn. Eamonn, good morning. How are you? You might be muted, Eamonn.
My apologies. I was about to say, I would say good morning to you, and you could say good afternoon to me.
Oh, where are you?
I'm in Belgium.
In Belgium. Look at that. So all the way across in Belgium. What time is it there?
Oh, it's about 5 p.m., just at 5:15 in the afternoon.
Evening, and where I am, it's after 10, and where you other people are, it's different time zones. So we're all here collaborating on this, and it's good to see you. So I'd like to bring you into the conversation as well. Can you give us some context on how Cloud Carib fits into all of this?
Well, as you have indicated at the introduction, Cloud Carib is a managed service provider, and we provide core supporting services for front-facing applications. So, for example, we cover network infrastructure, hardware provision, hypervisor management, virtual hardware environments. We manage operating systems, and of course, security, both in terms of cybersecurity and, depending on clients, also operational controls for data centers. So most of what we do is related to the back office, if you want, of digital transformation projects and digital projects for both government and commercial entities. Now, with regard to where we fit in with all of the GDPR legislation and its impact on us, I would say that basically we have, I would say, 5 kind of core areas where I would say we need to address in the context of GDPR. And the first one of these is really to determine what our role is in the context of the GDPR. And basically, we're looking here at, are we a data controller, or are we a data processor, or are we both? Now, for Cloud Carib, given the kinds of services that we provide, we may be, which are supporting services, we may be considered predominantly as a data processor. And this differentiation is important with regard to relationships and contracts between data controllers and data processors. However, just to confuse things a little bit more, we're not necessarily a data processor in every case. So if we were to provide some additional services, for example, secure Active Directory services, identity and access management, data key management, these kinds of services, then in that instance, we could easily be known as a data controller. And as a further example, we as a company have staff. We have a HR department. We collect information about our staff, which is also PII related data. So in that instance, we are also a data controller. But the core work that we do is really that of a data processor. So this is the first thing I believe that companies who provide services need to understand where they are located as regards to their role within the GDPR legislation. That's the first thing. The second thing is once one has identified that, and if for example, with Cloud Carib, we consider ourselves as data processors, then the contracts we're going to have with data controllers or the owners of the data should become more descriptive and more detailed in the new GDPR environment. So if I give an example of the Jamaica Data Protection Act, it says, and I'm quoting from the Act here, where processing of personal data is carried out by a data processor on behalf of a data controller, the data controller shall not be regarded as complying with legislation unless the processing is carried out under contract, which is made or evidenced in writing, and under which the data processor is to act only on the instructions of the data controller. These simple statements change the dynamic of contractual relationships between a data processor and a data controller, so service providers and those who own the data. The third aspect is how we manage and control our own internal systems. We will have to meet rigorous standards to comply with GDPR requirements. So for example, the Barbados GDPR legislation states that a data controller shall only use a data processor who shall implement technical and organizational measures to ensure that the processing is in compliance with the GDPR legislation. So we as data processors, we as service providers have to look at our own internal controls, look at the technology that we use, and be able to document and to prove to the data controller that we can meet GDPR requirements. So for example, as a data processor, we would have to fully understand and document what our IT systems are, what we use, wherever there is PII data stored, what security protocols are in place to protect data, and not only cybersecurity for external facing applications, but also internal controls. How the PII data is stored, how the data will be transferred from one entity to another. One of the aspects of digital transformation at the government level is the need to share information between government ministries. So typically, a data processor or a service provider like a Cloud Carib could be responsible for the infrastructure that allows that exchange of data. In that instance, we will have to document how that data will be transferred, who will have access to that data, and in what form. And of course, we would have then to adhere to data retention schedules and also determine how data will be erased to the satisfaction of the data controller. The fourth issue is the need to employ data privacy or data protection officers within the organization. So we will have to look at that with regard to the data privacy regulations and guidelines of each country.
Eamonn, you're muted. Audio just went. I don't know if he's hearing me. Eamonn, you are muted. We're not hearing you.
You can hear me? Okay.
Yes, now we can hear you.
Yeah, hopefully I was not muted for too long because something just popped up and it muted me. The fifth point I was making is about the breaches of data privacy and the consequent fines for breaches. We have to take that into account, and that has to be a very serious part of considering how we conduct ourselves with our clients. And we've already seen in the European Union significant fines on major corporations providing various cloud services. And my final point on this, I think, is to say that for us as Cloud Carib, we've been preparing for this legal environment for quite a few years now, I think going back at least on 2015, 2016. And we've done that by providing detailed service level agreements, getting certification internationally with recognized standards, and recognizing the need to implement industry best practices. And ultimately, as a service provider of managed cloud services, we have no choice. Within the GDPR environment, we have to employ standards, we have to employ controls, otherwise we won't be employed ourselves.
All right, thank you so much, Eamonn. So it is my understanding, though, that these GDPR regulations fall into the scope of the 8 data principles, which, among other things, speak to the fair collection of data, the proper disposal of data as well, data accuracy, etc. But because these laws are relatively new to the region, I imagine that there is still so much that people don't actually know about them. So as a legal expert in GDPR, Rishi, what are the main misconceptions that you have come across regarding data protection in the region?
Yeah, I think that there are several misconceptions that companies and people have when they hear the term data protection. I think the first misconception is that you believe that you need to have consent for every time you process someone's data. Now, consent is important and consent is also relevant, and all data protection laws speak to the notion of consent. But consent isn't the only reason or the only legal basis that you can use to process data. So, for example, under most GDPR-based laws that we have in the Caribbean, there are several legal bases that you can use to process someone's data besides consent. One would be if you have a contract with someone or if you're entering into a contractual relation with someone, then obviously there would be some understanding that personal data would be exchanged to allow for that transaction to go through. So if you fall within the category of either A, you're engaged in a contract or you're entering into a contract with someone, then you don't need consent to be able to process that data. And then there's also the whole idea of legal requirements, because many companies out there act or have legal obligations to collect certain types of personal data. If I think of financial organizations, for example, under the anti-money laundering laws and regulators, they have a requirement under the law to collect certain data for risk purposes and everything else. So if there's a legal requirement to collect certain data, then you don't need to again get consent. Also, if you're a public service or you're operating in a public sphere and you're collecting data to deliver public goods for someone, again, you don't need to collect consent. So that's one misconception. Another misconception, I think, is the whole idea of data protection stops innovation. We know many organizations are now adapting to technology and utilizing stuff such as artificial intelligence, AI, machine learning, data analytics to be able to use the data that they have to be able to manipulate the data to again best serve their clients and customers and to meet the bottom end, which is of course profitability. But many people feel with data protection laws, well, I can't do that anymore. I think that's another misconception. Data protection laws were never meant to stop companies innovating or to stop companies, using profitability or utilizing technologies in a new way. What data protection does is that it says that if you are going to go down that route and use data in different ways or utilize new technologies, then you need to understand the risk of operating in that environment. You need to do a proper risk assessment. So most laws, for example, Barbados and Jamaica, mention something called a data protection impact assessment, which is a risk assessment you do to understand what the risks are. And then once you know the risk, you put the mitigating controls in place to minimize the risk as best as possible. And in some cases, you need to get the approval of the commissioner, or the commissioner needs to know what's going on. So there's oversight and accountability. And again, by playing within those lines, you can continue to innovate and use different ways. But you need to understand that you're using someone's personal data, and you need to understand the risk involved and then put proper controls to mitigate those risks. Another one is, I think Eamonn mentioned it, the whole idea of sharing. Some companies, obviously, in the environment we live in, share data among other companies, third parties, for different reasons, within their country, out of their country. And again, many people feel with data protection, well, this has to stop. I can't, for example, hire or use Cloud Carib, which may be based in another country, to store my data or anything else. And again, no, that's again another misconception. You could, but again, there are laws and there are lines that you don't have to play in. You need to do a proper due diligence assessment of third parties. You need to have a data sharing agreement in place. or a data processor agreement in place with third parties or other companies. You need to document the type of data you're sharing, why you're sharing it. All these things, again, are important for you to do to, again, balance the whole idea of the risk and the responsibility of companies. So those are just some of many I can talk about, but off the top of my head, I think those are the three most common misconceptions people have regarding data protection laws.
Well, I'm glad you cleared that up because I had all three of those misconceptions. So perhaps I can amend my answer in the poll a little bit later. So Eamonn, as the public sector director for Cloud Carib, you've had a front row seat to the ways that data protection legislation has actually evolved and is continuing to evolve in the region. So can you give us perhaps an idea of some of the key differences that you've noted between data protection laws, say in Barbados or Jamaica versus what exists in the Bahamas? Muted again, Eamonn.
Sorry, I would bow to Rishi's expertise. I'm not a lawyer, but reading the legislation from let's say a company perspective to look at how we might have to implement certain things. I have identified a couple of differences, and there may be nuanced differences or significant differences. But let's say in the case of Barbados, there is a requirement, and same in Jamaica, there's a requirement for data controllers and data processors to register with the data commissioner. So in the law in Barbados, it states a person shall not operate as a data processor unless he is registered in the register of data processors. I have not identified that particular equivalence in the Bahamas data privacy legislation. Another aspect is maybe again a nuanced difference where in the Bahamas the statement concerning hosting data externally to the country, there's a statement that the commissioner may, subject to the provisions of a particular section, prohibit the transfer of personal data outside of the Bahamas. But the same statement coming from Barbados states personal data shall not be transferred to a country or territory outside Barbados unless that country or territory provides for adequate levels of protection. So there are some nuanced differences in the language that's presented, which as non-legal people, we may have to seek advice from people like Rishi as to what the nuanced difference means and what the impact on our business processes and our business is going to be. The third most striking one for me was the need to have a data privacy officer or data protection officer, as it's known in the Jamaica context. That again is not something which is referenced within the laws, the data privacy laws of Bahamas, but it's there in Barbados and it's there in Jamaica. It doesn't mean that Cloud Carib, for example, has to necessarily have a data privacy officer in place, but we would have to look at the requirements and the guidelines and the regulations to identify if we have to do it in the context of business in Barbados and in Jamaica, but not necessarily in the Bahamas. So they're just a few, because the legislation is being developed at a national level, there may be other nuanced differences between countries, and that is something that we have to look at as a company in order to ensure compliance.
So then, Eamonn, as a follow-up, how are companies like Cloud Carib impacted by the differences in these laws, especially since you operate as a multi-jurisdictional company?
I think at the moment it's a little bit early to say that because the data privacy legislation and particularly the GDPR model is relatively new and the impacts are still being worked out. Of course, for a multi-jurisdictional operator like ourselves, we would have liked to have, let's say, an overarching regional standard for GDPR. So if regardless of which country we operate in or out of, the rules would be more or less the same, and the interpretation of the laws would be the same. That would certainly make things easy for us to be compliant. And let's say in an ideal world, if we are based in the Bahamas and we are fully compliant in the Bahamas, that would automatically say we are compliant in Barbados or Jamaica or Guyana or Belize or wherever. That would certainly reduce our potential costs for bringing ourselves up to compliance in each jurisdiction. So a standard based maybe on CARICOM standard or perhaps even a CTU standard if that was applicable could be very useful to have a common approach. And that would not only be for companies like Cloud Carib, which are multi-jurisdictional, but perhaps also for individual companies who might want to acquire services in another country. And Rishi has touched on this, that due diligence has to be done to ensure that you're complying with your local data privacy laws if you want to do some activities outside the jurisdiction. So perhaps if there was a common jurisdictional approach and common GDPR approach, that would be something very beneficial for those players in the digital sphere.
Thanks, Eamonn. I see some questions starting to slide in the chat as well. Let me just remind you, participants, we prefer if you use the Q&A tab to ask your questions, just so that it's easier for us to find those questions when Q&A time comes and they don't get lost in the chat. You can find the Q&A simply by clicking the 3 dots in the lower right corner of your screen. Click those dots and you'll see Q&A pop right up and it will be added to your right panel. And I saw a comment from Frankie earlier saying this is very powerful stuff. So yeah, information is quite useful. So let's get back to Rishi. You've talked about some of the common misconceptions surrounding data protection legislation, but I'd like to hear your insights as well on regional compliance. Now, I know that here in Jamaica, businesses have been given a deadline of November 2023 to become compliant with data protection laws, and there's been some concern in the business community that the business community may not be moving swiftly enough to do so. I've heard those concerns for sure. From a legal perspective, though, how can Caribbean organizations mitigate the risk of non-compliance with national data privacy legislation? And could you also speak, this is what we really want to know, to the penalties or the fines levied on those?
Yeah, I think that's an important question because you mentioned Jamaica. So Jamaica's law was gazetted. So companies in Jamaica have until November 2023 to begin before the law fully becomes enforceable. But I think on a webinar I was on a couple of months ago with the commissioner in Jamaica, she noted that there may be certain parts of the law that may be enforceable depending on what action may need to be taken. So I think companies first need to understand that data protection is here and it's not going to go anywhere. And you need to take the necessary steps in order to be able to comply with the laws. And that would be first understanding the law, understanding your jurisdictions. There may be companies who may be multi-jurisdictional, like Cloud Carib, like many conglomerates we have in the Caribbean. That maybe you have companies that operate in Jamaica, in Trinidad, in Barbados, up the islands, in the Virgin Islands, or you may be a company that may be looking to target EU nationals. For example, let's take the hotel industry and the tourism industry, which actively targets nationals in the EU. You need to be aware of the laws and the compliance laws that fall under you. You need to, what I would call, we know in the financial services sector, it's called KYC. You need to know your customer. But organizations need to KYD. You need to know your data. You need to know what data you collect, how you collect it, the total life cycle of the data from collection to use, to sharing, to transferring, to when you no longer need it anymore. And you need to, what we do call a data mapping exercise, or develop a record of processing activity, or ROPA. I know the Barbados law, for example, speaks to that, where controllers in Barbados and processors need to develop an active record of processing activity. You need to understand your data. You need to understand everything about it. And by that, you'll be able now to see where your gaps are in your organization, in the law, and then fill in those gaps with a proper compliance program in place. Because there are risks, and you mentioned one of the risks are financial. I mean, if you look at GDPR, for example, GDPR's fait accompli is that your fines could be up to 4% of your gross worldwide profit. So that could be in the millions and millions of dollars. I mean, one of the differences we've seen in the Caribbean laws, for example, in Barbados, their fines aren't as exorbitant as GDPR, but it's still a fine nonetheless. That could be very not good for companies depending on your size and scope. Even if you're a big size company, but you get fined, that also has reputational damage towards it. So you need to be aware of that. So Barbados's fines are about, I think, 250 or something Bajan dollars. And in the Jamaican law, for example, their fines, I think, follow a bit of the GDPR model where you could be fined up to 4% of your gross turnover, depending on the company. Their liabilities for directors, their liabilities for senior management in data protection laws. So again, this is something that's not a front end problem.
A lot.
It's a broad problem. It's a business problem that you need to be aware of, because the liability would fall with the board or with senior management. So this is where people need to be aware of the risk involved of non-compliance. Because one approach that could be taken is, well, data protection is not important. We'll just do the minimum. But what we're now seeing in the world, and I should say that most of the regulators here in the region, even the new ones in Barbados and Jamaica, are actively seeking guidance from the Information Commissioner Office in the UK, from other regulators in the EU, as to what they need to do to be effective regulators. And worldwide, regulators are now moving away from the checkbox type of mentality where we have a privacy policy, check, we have these documents, check. They now are moving away from that checkbox mentality to now actively saying, what are you doing?
Yeah.
You don't just need to show us documents and policies, but you need to actively demonstrate that you're complying with the law.
Yeah, so that's the legal perspective. And Eamonn, I also want to bring you here in on the technical perspective. So how can Caribbean countries mitigate risk of non-compliance with national data privacy legislation from a technical perspective?
Well, I think the first, I guess, comment I would make on that is implementation of sovereign clouds will certainly go a long way to doing that. Now, sovereign clouds are implemented to ensure that data is subject to only the jurisdiction control and authority of the nation where the data is collected and where it resides. So that's certainly one, you mitigate the difficulty of trying to interpret whether your extrajudicial partner or data processor, whether they comply with your legislation. So sovereign cloud is something which is gaining a lot of traction, as a matter of fact. And it also allows for the easier establishment of security frameworks to meet national compliance. So there are two kind of critical things that could be very useful is sovereign cloud, something that Cloud Carib has been promoting for some time. And certainly from our perspective, when we speak with governments, we indicate where sensitive data is required. And we're not only talking here about PII data, but other sensitive data. We will then implement a sovereign cloud for that government. In other words, we will put the infrastructure in their jurisdiction so that they can comply with national laws. That's one aspect. The second aspect, of course, is that service providers, and service providers, can be a broad term because it can also be government IT departments, commercial operators, and service providers like ourselves, is to ensure compliance and eventually certification in international standards, particularly those relating to data security. So, for example, you mentioned that Cloud Carib is SOC 2 compliant. That's covering both organizational as well as security matters, ISO 27000 on security, also ITEL, so ITEL certification, which is a framework designed for selection, planning, delivery, maintenance of the overall life cycle of IT services. So implementing that is something that I think is another standard. When we come then to the data center standards itself, uptime tier 3 or tier 4 data standard certification. So these are just examples of kinds of certifications that when they're obtained by an entity and maintained by the entity, it means that you have a high confidence in their ability to deliver GDPR compliance. So as was mentioned, Cloud Carib is SOC 2 compliant. We've been independently audited to attain that status. The people who work in our command, control, and communication center, which is known as C3, that's our monitoring center, which operates 24/7, 365. All the personnel in there are ITEL certified. And then we can also look at industry standards like the Cloud Security Alliance, for example. That's another organization that looks at security, trust, and assurance for risk. So we obtain standards from them as well. So I think the critical thing here is to look at standards and to get and compliant with these standards.
Standards and certification, absolutely important. So we've come to the point where we're ready to take our second poll, and I see a lot of questions coming in the Q&A now, and we're going to get to those questions in about the next 5 minutes or so. But first, let's take our second poll. Is your organization in compliance with data protection laws in your territory? So this is a tricky one, and just reminding you that the poll is anonymous, so don't be embarrassed if you're not. Just be honest. Is your organization in compliance with data protection laws in your territory? You should see that popping up now. And let me answer, because for me, I'm going to click unsure. I don't know if we're compliant, which probably means that we're not. So let's continue, and we're going to take your responses a little bit later and see what most people were responding. As we get to, before we get to those questions, Eamonn, my next question is for you, particularly since much of your career has focused on encouraging digitization across governments. I'd like you to weigh in on the technical perspective, and then Rishi, perhaps you could jump in on the legal perspective as well. But here's the question. As organizations and Caribbean governments move to digitization, how will data privacy legislation impact the digital landscape of the Caribbean?
Well, I think the first thing to say is that many digitization or digital transformation projects in the Caribbean are public sector driven. So that's certainly one point. And we've seen this, and I think Rishi has mentioned this earlier on in his comments, during the COVID pandemic, there has been a ramp up of the use of various services. And most of these services, whether it's virtual classrooms or virtual meetings or using other cloud services for remote working purposes, most of these services are outside the jurisdictions of Caribbean countries, if not all of them. And most are hosted in the United States of America, with likes of Google and Microsoft and Amazon, etc. And now, so this is less a technical question, but more maybe a legal question, and it's a question that I'm posing. The contracts that have been signed with entities where you have your PII data in other jurisdictions today, would they need to be renewed? Would they need to be reviewed to ensure that they are complying with GDPR legislation, which is more or less come into force during the pandemic and after the pandemic? So there's a bit of catch up to do here, and the question is, do such contracts need to be renewed or reviewed to ensure compliance with GDPR? And it's worth in that context noting that based on the fact that particularly countries like Barbados and like Jamaica, their GDPR model is very closely aligned to the EU, and the EU does not recognize the United States as a safe jurisdiction for EU PII data, then that should at least put a flag up to say, perhaps we need to review this. And this notion of the EU not regarding US as a safe jurisdiction has come up through legal challenges in the EU and the striking down of the Safe Harbour Act that was in place between the EU and the US. So right now, the US is not a safe harbour for EU PII data. So those countries with GDPR model on EU, they should probably look at their contracts and see if they're in conformance with GDPR legislation. And also, I think for the future, particularly those responsible as data controllers, and I think this is also an impact on how GDPR will affect the implementation of digitalization projects. It's not only people working in government IT departments that are now subject to GDPR, but also the heads of ministries, like permanent secretaries and CEOs of government departments and ministries who are implementing digital solutions where PII data is required. They are now data controllers under GDPR legislation, and they can't just leave it up to the IT department to say, you need to secure our data, and I'm done with that. They will be responsible as data controllers. They will be responsible for their data. And that means they're subject to penalties and subject to data breaches themselves.
Right.
So
Eamonn, we're gonna have to leave it there because we're low on time and we have a whole bunch of questions to get to. I want to get to these questions. I see the comments were coming in via read the poll as well. But let's get to the questions. 17 questions. We'll get to as many of them as possible in the time that we have left. And even if we don't get to your question, we will still take a note of it and you will be responded to via email. So let's start with this one. The first question came from Anthony, who said, EU is made up of approximately 27 European countries and the GDPR is an EU law. Would it not be more prudent if the Caribbean or CARICOM comes together and develops a data protection law? Perhaps that one might be for Rishi as the legal expert.
So we did try it in the Caribbean. I think way back in 2000, late 2000, early 2010s, there was a project led by the ITU, the International Telecommunications Union, and the local arm here, something called the HIPCA project, in which they wanted to develop a framework of laws for the Caribbean around areas such as e-transactions, electronic transactions, data protection, freedom of information. I don't think we got much traction in that because the whole idea of that project was, as the question asked, to create a framework. I don't think we got much traction in that. I think it's a laudable idea that we may have a similar type GDPR. I mean, some people have floated the acronym CDPR, a Caribbean Data Protection Regulation. I think that's a question for the governments to add. I think it would create standardization across the board, and it would be very useful for multi-jurisdictional companies. But I don't see that honestly happening anytime soon.
I just saw a comment saying like the fizzling out of CSME, don't see it happening anytime soon either. Next question comes from Damian Franklin. How are companies governed under credit reporting legislation affected by data protection legislation?
Can you say that again?
How are companies governed under credit reporting legislation affected by data protection legislation?
Right, so that's involved, obviously, for credit rating agencies, you need to obviously share certain types of data in order to create a profile, a risk profile of someone. And that's where, I guess, you see where data protection laws, particularly, even not only in the Caribbean, but in the EU, it's evolving with all these different requirements and questions that come up with regards to sharing that type of data, the sensitivity of the data, and credit rating agencies using this type of information to create a risk profile. So you need to have an idea as to if you have to share data with credit rating agencies or your credit rating agency, you need to understand what's the purpose for the data, why do I need to collect the data, what type of data do I need to collect? You pull up a slide earlier with regards to the principles. One of the principles of data protection is data minimization. I only collect the data that I need, and having proper technical controls and security controls with regards to who shares the data, who accesses the data, and security. So again, it's all about understanding the nature of the data and how you're going to use the data. And you need to have a good justification documented in case questions do come up as to why are you sharing this data with credit agencies, or if you're an agency, why are you collecting this data? So it's all about documenting and having proper documentation to be able to demonstrate why you're doing it and you've done the proper due diligence for it.
Next question comes from Daniel, who wants to know, how does the MLETR fit into all of this discussion?
So
I think that might be for Eamonn.
Well, that's a legal thing, but I'll do my best. So that is the model law on electronic transferable records, which is a United Nations UNCITRAL law, let's say, generic law. So I would say, and it's about recognizing electronic or digital records as documents to be transferred and recognized. And I think how it fits into here, I guess it would depend on what is contained within that record. If there's PII data within that record and it's transferred, then obviously it will have to be transferred and managed and handled in the same way as if you had an electronic document of another description stored on a file server. It has to be handled in a way that is GDPR compliant. So I think there's two laws that might come into play here. One would be just recognizing what let's say a document is, like it's a digital document or digital record. That's one thing. And then how that document fits in with GDPR would be how it is, what data is in it, and how that data is handled and transferred and stored like any other data record.
Next question comes from Sheena, who wants to know, will there be a requirement for the data processor to complete annual tests to ensure understanding and compliance?
I didn't see anything in the legislation that would require it. However, if you're going to comply with like ISO standards and SOC 2 and stuff like this, you will have to have regular audits to ensure that you are maintaining the standard. Because with standards like this, it's not a case of we get the certification and then we can just forget about it. There has to be a continuous process of examination and audit to ensure that the company continues to comply with those standards. So I don't believe, and maybe Rishi can speak to this, I don't recall seeing anything in the actual GDPR legislation to say the data processor must have an annual review. However, when you come to deal with your controller of the data, you will have to demonstrate that you are in a position to comply. And the one way that you can be sure of doing that is to, as I said, obtain international standards and maintain those standards, which will actually require continuous audit.
Yeah, and I'll just add to that again, it comes on to your data processing agreement you have with the processor, that you have in it built into the processing agreement, the ability to audit. And good practice now is that you should probably do a yearly audit, just again to ensure that the processor maintains the standards that they've alluded to in the initial contract, not everything is above board. So again, keeping understanding of the different processors that you have in place, having good data processing agreement that allows for auditability of the processor. And this could be by simply just sending certain questionnaires again every so often, so they can demonstrate accountability through certification, attestation, or other things that they could provide you again, so you document it as best as possible. So in case again the regulator comes asking questions, you have documentation proof to show that you regularly audit or get certain types of documents from your processor to show that they are compliant.
Right. So the next question now comes from Eustace, who says, a lot of organizations have retention and data disposal policies in place, but are not actively implemented. How would you advise businesses go about implementing a retention policy and purging data that has expired, especially for a business who's accustomed to keeping all the data that they've collected?
Yeah, I know this is a game where we like to write policies and have it, but don't enforce it.
Exactly.
Again, it comes down to the whole idea of knowing your data. So my advice would be that you need to do a proper in-depth data inventory, because again, data protection works with other types of infrastructure, such as data management, data governance. So you should do a proper inventory of your data. Again, like I said, know your data, KYD. Understand the types of data you collect, why you collect it, where does the data being processed, who uses it, what systems you have, where are those systems located. And then by understanding, first of all, the types of your whole data landscape, then you would then be in a better position to make decisions as to, okay, what data do we really need? What data don't we do need? Because again, going back to the principles of data protection, another principle is you only keep data for as long as you need it and not anytime more. So again, I would say you need to do a proper data audit of your systems, of your data, and then from there document it and then make decisions as to what you need, what you don't need.
Right. Next question comes from Max, who says, you've touched on the differences between Jamaica, Barbados, and Bahamas, but what about Trinidad?
So Trinidad, we have a data protection law that was passed way back in 2011. It was never fully implemented. It was only implemented in part to establish the Information Commissioner's Office. But as we speak right now, the government of Trinidad and Tobago last year engaged with a consultant to revise our data protection laws. They had stakeholder consultations with private sector and public sector organizations. And there is a draft bill that was supposed to be presented soon, I believe, this year to Parliament, because again, it's part of the government's digitization effort. And that draft bill again incorporates GDPR. So it's going to incorporate a lot of the elements of the general data protection laws to be in compliance with the other laws of Jamaica and Barbados. So I anticipate soon that the Attorney General will be bringing that to Parliament soon to make those passages of the act to bring it in line with GDPR, because again, the government is moving towards a digital transformation agenda.
Next question is coming from Eustace, who says, because of these laws, can government entities of public authorities simply request, I think that's PII or P2, I'm not sure, to enact, I'm sure you guys know what it is, to enact their duties without supporting legislation being passed?
No, I think so. You need to understand data protection laws and need to understand the wording of these laws. So these laws talk about enforcing the rights and freedoms of citizens. So if you actually read data protection laws and look at the wording, it goes just beyond data protection in terms of the rights it gives citizens under the Act, but it talks about the freedom. So we're talking about constitutional elements of the law that you can't discriminate and you can't do other things. And for example, we saw in Jamaica, where Jamaica, I think the government was looking to introduce the NIDS program, the National Identification System. And they passed the law and they were looking to implement it and they were taken to court. And the courts in those cases ruled one of the reasons that it was felt unconstitutional was because of the lack of a framework for data protection. So this is where, yes, public authorities working for public good could collect PII, but it not only comply with data protection laws, but you need to comply with other respective legislation, such as the Constitution, which is the supreme law of most Caribbean countries, in order to do your business properly.
Okay, we have time for maybe one more question. Let me see, this one here comes from Luxmore. The initial data protection laws in the Eastern Caribbean were done at a regional level. This was done in 2006 or so before GDPR came into effect. Would you be aware if there's another regional effort to have a uniform legislation? Hold on. Trying to get back to the question. All right, here we go. Would you be aware if there's another regional effort to have a uniform legislative update to the data protection laws?
Yes, so in Eastern Caribbean, I know just recently there was a tender that went out, I think last year, to invite consultants to begin to look at revamping and I guess revising the laws of the Eastern Caribbean states such as St. Lucia, St. Vincent and the Grenadines and Antigua. And again, it's about bringing the laws in compliance with the GDPR because that has now become, I guess, the gold standard internationally. So I know there have been actively pursuits from an Eastern Caribbean point of view to have a consultant come on board. So I anticipate, hopefully, all things being equal, that very soon we should see maybe in 2023, the Eastern Caribbean following suit. That being said, however, if you're a company in the Eastern Caribbean, but you're doing business in Jamaica or in Barbados or in the Cayman Islands or even targeting people in the EU, data protection would still apply to you because you need to be aware of your compliance regulations if you're doing business with other countries that may have data protection laws.
All right, so we can take this other one. T-Mac wants to know, are there suggested courses which data protection officers in Jamaica can participate in order for them to properly understand their jobs? And also, does a data protection officer have to be an attorney?
Okay, so the first part is yes, there are many courses out there. I would highly recommend the International Association of Privacy Professionals CIPM certification, which is a Certified Information Privacy Manager, and possibly a CIPPE. Those are good courses. There are also numerous courses out there from the University of Toronto and even the EU, a DPO course from a university there, I don't remember the name, that is very good that you can probably check into. Second question, does it have to be an attorney at law? No, a DPO does not have to be an attorney at law. Internationally, we have seen where DPOs could come from the IT field, from the compliance field, from the legal field, yes, but you don't have to specifically be an attorney at law. It can be an internal position. You can appoint somebody in an internal position to be your DPO. You can hire somebody externally to be your data protection officer, but it doesn't necessarily have to be an attorney at law. There are different fields because data protection is so wide and it covers so many different areas. You know, it doesn't specifically skill set itself to be an attorney at law.
Thank you so much for that. Well, our third poll is up on your screen right now. So we'd like to encourage you to take that poll. Does your organization have processes in place to ensure data security in case of an incident? So let us know. Just click yes, somewhat, unsure, or no. And remember, this is anonymous. So you're not telling on yourself if you answer no or if you're even unsure. So we are pretty much out of time, but I also want to encourage people or just let you know, participants, that if you had a question that we didn't get to, we will be emailing responses. Some responses were being provided to you privately in the chat as well. So if you look in the Q&A, you may see a response there from Cloud Carib directly in the chat or directly in the Q&A to your question. And any other questions, we will make an effort to respond to those directly via email to you. We want to thank you so much for participating in this event. I know you have learned a lot. I have learned a lot. Data protection is something that is becoming increasingly important, increasingly talked about, especially here in Jamaica as the deadlines approach. 2023 is right around the corner and it is coming fast. And all around the Caribbean, this is something that we need to pay a whole lot more attention to. So remember, if you have questions on how to develop a data privacy or data protection strategy for your organization, you can always reach out to Cloud Carib. You will be sent additional resources following today's session, including a recording of this webinar, since many of you were asking, and other assets which can provide more clarity for you. You can email contact@cloudcarib.com. So that's contact@cloudcarib.com, or you can visit their website for more information, and make sure to check out the blog for more helpful articles as well. We want to thank you all for taking the time out to participate in this webinar, to join our webinar. Thank you to our panelists, Eamonn, Sheehy, and Rishi Maharaj. I'm Kalilah Reynolds on behalf of the entire Cloud Carib team behind the scenes. Thank you, and have a safe and productive week.